Welcome to Federal ER Pro, where we explore the craft of casework. Today we will be discussing gathering employee and witness statements. In this course, we'll cover how to properly gather, document, and preserve critical testimony in administrative misconduct cases. Statements play a critical role in any workplace inquiry, and the way you collect them can either strengthen your case or weaken it.
Not every workplace issue gets assigned to a trained investigator. Often, supervisors must conduct an inquiry themselves. Most supervisors lack formal training in questioning, evidence gathering, and documentation. That's where employee relations becomes critical, shaping the questions, spotting CBA triggers, and ensuring quality evidence is gathered.
Administrative inquiries, even basic ones, can make or break a case. The quality of your evidence impacts decisions by MSPB, EEOC, and labor arbitrators. If a situation needs more than basic documents or statements, supervisors are usually not equipped to handle it, and a formal investigation should be considered. Often, the strongest evidence in a management inquiry will be the statements from employees and witnesses. Federal supervisors are expected to gather facts objectively and promptly when misconduct occurs. Early collection preserves memories, strengthens the agency's record, and shows procedural fairness. Contemporaneous statements, meaning close in time to the event, carry much greater weight. This has been emphasized by the Merit Systems Protection Board.
Now, a critical caution. Bargaining unit employees have Weingarten rights. These rights apply when management conducts an examination linked to an investigation, the employee reasonably fears discipline, and the employee affirmatively requests union representation. They aren't automatic. The employee must specifically ask. If you're not familiar with Weingarten rights and you work with bargaining units, you need to remedy that, and soon. Another important rule, the Privacy Act, under Section 552AE2, agencies must collect information directly from the subject employee and whenever practicable. This usually means you approach the subject first, before coworkers. Unless you have a strong reason to suspect tampering or obstruction, failure to do so can result in Privacy Act violations, as seen in Waters v. Thornburg.
Now for some advanced info, you should know what Garrity and Kalkine's warnings are, but don't wade into these waters alone. Always consult your agency's legal staff if you have even an inkling that one of these might be necessary. Usually, a workplace inquiry starts with a complaint from one employee about another employee. Sometimes the complaint comes from outside the agency. For example, a member of the public witnesses an employee driving aggressively in a vehicle with an agency logo and calls the local office to complain. An inquiry often starts with a complainant, the person who first brings forward a concern or allegation. When we interview them, the goal is clear. Pull out the specific facts they know, the basis for what they believe, and ask if others witnessed the events or if there are any documents that back it up. We want to be thorough, but focused, making sure we address all the right issues based on facts, not assumptions.
Witnesses are critical to building a solid inquiry. They provide first-hand details, the who, what, when, where, why, and how, that bring events into focus. We reach out to all witnesses, even those outside the agency. If an agency employee refuses to participate, we document it immediately and make appropriate notifications. Credible, reliable testimony. That's what gets to the truth of the matter and strengthens our findings. The subject of an inquiry is the person accused of misconduct, mismanagement, or other failures. Our focus: gather evidence, assess the allegations, and stay fair. This isn't about building a case, it's about objectively reviewing the facts. The goal is to find out what did and did not happen. Fairness and neutrality aren't just guidelines, they are mandatory at every step.
There are several options for gathering statements. Supervisor-led live inquiry. Supervisor-created summary signed by the witness. Written questionnaires, and video interviews followed by a written summary. Choose the method that fits the situation best. based on complexity, timing, and available resources. In-person interviews are generally considered the best options as they allow follow-up questions and observation of demeanor. The reality is that without training, supervisors may ask leading questions, take inaccurate notes, or skip follow-ups. Also, in union environments, Weingarten rights complicate scheduling and process control.
Video interviews are now a practical option. Conduct the meeting via Teams or Zoom on agency-approved platforms. Afterward, send the employee a written summary to review. Optionally, have the employee do the review and signing on the spot. A few points: do not record the session, unless you have express written permission. Obtain a proper signature, either through CAC/PIV authentication, an approved e-signature tool, or classic print sign scan. Remember, always check your agency policies and any CBAs. Virtual technology opens even more options. For example, an employee can share their screen, answer pre-written questions in their own words, and the inquiry official can read along and ask follow-up questions. This process also allows union representatives to call in remotely if Weingarten rights are invoked. Think outside the box. Regardless of the current slashing of remote work, we live in a virtual world, and this new mode of communication is not going anywhere.
At Federal ER Pro, it is our assertion that the questionnaire method inherently meets the intent of Weingarten rights. Make sure to give a few business days to answer and return the form, dependent on the length and complexity of the questions. This ensures the employee had time to consult the union, should they wish to do so.
Let's talk reality. An in-person, supervisor-led inquiry only adds value if the supervisor is highly skilled. Otherwise, a well-drafted questionnaire can be just as effective and less risky. Written approaches reduce last-minute union coordination issues, speed up documentation, and create a cleaner administrative record. Draft a questionnaire or statement form for your customer. Include any policy language regarding compelled cooperation. Include a clear due date and time. Preload it with relevant questions and clear instructions, as well as some general guidance. A statement form offers opportunities to put a lot of thought into the questions and instructions.
Sometimes employees will become law and order experts and try to plead the fifth. Federal employees have a duty to cooperate in administrative inquiries. The Fifth Amendment protects only against criminal self-incrimination. Here are some ways to handle this situation. It's a good idea to prepare inquiry officials to respond ahead of time. Now let's talk about getting signatures. Ink signatures, digitally certified, these are options we all know are best practices. But something that is often overlooked is a perjury clause. Even some of the most experienced ER practitioners believe that a statement sworn before a notary or with hand raised in front of a credentialed investigator is the gold standard. The reality is, an unsworn statement, signed under penalty of perjury, is legally equivalent when done properly. This method is recognized by MSPB in courts. Wrapping up, there are several strong options for gathering statements. No matter how complex the case, statements will almost always be at the center of your evidence. The more proactive you are now, the more secure your case will be later. Don't leave supervisors, our customers, to figure it out alone. Gathering statements is both an art and a science. Early, properly documented, perjury-affirmed statements are critical to defensible ER cases. Understanding how to manage Weingarten, Fifth Amendment issues, and statement quality can make the difference between success and failure.
Thank you for joining this session. Remember, strong statements create strong cases. This is Federal ER Pro, sharing info, not legal advice, and helping you master the craft of casework.
Remember, this is not legal advice. You need to check your policies, your CBAs, and any and all citations. Please check back for more content. Like, subscribe, and share.